So right now you're under arrest for suspicion of murder, 30th of July. You don't have to say anything, but it may harm your defence if you do not mention, when questioned something which you later on in court, anything you do say may be given in evidence. Obviously, necessity is going to be competent, effective investigation to prevent further harm.
You may remain seated for now. On the 30th of July last year, you were simmering with rage throughout the evening, having been arguing with your ex-partner, Karen Thomas, and her family. I am sure that in your frustration and anger, you planned to have a violent confrontation with one of the Thomas family that night. In fact, you threatened as much in an earlier message and in conversations with Karen, and I've seen a message which states that you're going to show her something and to watch this space. You can be seen on CCTV in the street just prior to this killing, walking with your hood up at one point. You go back to your vehicle and you start to drive away. You should have kept driving, Mr. Williams. You saw Derek Thomas. He was 55. He was walking along. He was on his way home from work as a bus driver. He was wearing his headphones. He was listening to music. He was carrying shopping for his family and was oblivious to the arguments that you'd been having with them that night. He was minutes from his home. Instead of driving away and calming down, you pulled up and you jumped out of the van. And you had with you a large knife that has been described as almost a sword with a curved tip. Witnesses saw it gleaming. You ran towards Mr. Thomas. You confronted him. You stabbed him through the side of his torso and into his heart. He had incised wounds on his ear and on his back. The pathologist described the fatal injury as unsurvivable. Mr. Thomas died there on the street, minutes from his home, with the shopping that he had bought strewn around him. I am satisfied, having heard the evidence in this case, that he carried no weapon and was completely unarmed and defenceless. By its verdict on count 2, the jury was sure that you had that 50-centimetre long knife with you when you got out of the van. Derek Thomas was a loving, kind, hard-working, helpful and gentle man. He was always there for his family, his friends and his community. He was a useful and a productive member of society who tried to do good and was an irreplaceable part of many people's lives. His sister, Blondell, has read the impact on her to this court and has, during that process, found the dignity to show thanks to others. His daughters have told the court about the terrible consequences of this loss, both in their lives and those of the wider family, including young children. There is a deep sense of betrayal of trust and of trauma that the circumstances of Mr. Thomas's death have left. His children speak of the unfairness and the pointlessness of it, and the sadness, says Jade, filters through the whole family. Carol feels the lost in grief. She's unable to believe that she won't see her dad again. Mr. Thomas's sisters bring him back to life in the words in their statements. His bright smile, his love of football and family, his sense of humour, his wisdom and his kindness. They contrast his good life with the suffering that his family must now endure and the senseless loss of his death. Finally, his wife, after 35 years, must learn to live without him. Every day, she says, is a battle for her, and she told the court that he's always on her mind and will be forever in her heart. This devastation is apparent in the faces of this family who have sat in court every day. Given the eyewitness evidence that I've heard about your actions, I am sure that you intended to kill Derek Thomas. This was a merciless and determined attack. You killed him even though at one time you saw him as a father figure. You knew how important he was to his wife and his children, as you'd lived alongside them for 2 years. You knew that targeting him would hurt them all. Mr. Derek Thomas had nothing to do with the petty arguments that you were having that night. Your account was rejected by the jury, but it still relied on in mitigation, which submits that this was not a premeditated attack with an intent to kill, and I reject that analysis, and I do not accept the characterisation of this as a chance encounter with tragic consequences. When you spotted Mr. Thomas walking home, you had time to pause, you had time to think, you had time to consider what you were doing. Having seen you give evidence and heard the witnesses, I agree with the prosecution's case that you picked a soft target. He was completely unaware of your presence until you appeared before him wielding a large knife. He did not have a chance. You targeted him for revenge because of your own fury, and I am sure that to this extent this was a planned and targeted attack motivated by anger and directed towards the Thomas family. This murder took place in a residential street at night with members of the public witnessing this savage violence. And then you made off immediately. You disposed of the weapon in the river. You then went on to evade justice for a month. At one stage you were chased in a car by the police, and the jury saw this pursuit and the way that you were determined to escape. You gave false names to the authorities, and then again when you were discovered at the Notting Hill Carnival and arrested. You, in my judgment, having seen you, have been determined to save your own skin throughout this case, with no thought for the family of your victim and no remorse. You blamed Mr. Thomas for attacking you with a knife, and the anguish and suffering of his family continued throughout the trial. The children of Mr. Thomas are also blameless in this terrible crime. You alone are responsible for this killing and no one else. You have convictions for 8 offences of robbery from 2007 and 2014. In 2014, you committed an offence with an imitation firearm. On 2 occasions, you possessed an imitation firearm with intent to cause fear of violence, for which you received a total of 9 years imprisonment. You have a battery conviction from 2022. Therefore, it's quite clear that you have a history of violence and possessing and threatening weapons, albeit firearms, not knives. You have driven whilst disqualified on a number of occasions in contravention of court orders, and at the time you committed this offence of murder, you were disqualified from driving and had been for some years. Kamar Williams, the sentence for murder is life imprisonment. That's the sentence that I will pass on you. I must by law set a minimum term that you must serve of that life sentence before you can even be considered for release. I make it very clear that the minimum term is not the sentence is a life sentence. If you are assessed as a danger and a risk, you may never get out. Be in no doubt that you could spend the rest of your life in prison if the parole board consider you to remain a danger. The law says that I must start calculating the minimum term that you must serve at 25 years. I must look at the overall seriousness of this case and recall the evidence that I heard from witnesses and from you. In my judgment, you showed no mercy towards your victim, either at the time that you killed him or in your attitude afterwards. Those who saw this happen described the speed, the suddenness and the savagery of the attack. I add to this starting point of 25 years factors that make this murder even more serious. A plan to do harm given the earlier texts, your behaviour in the street where the Thomas family lived, and the time you had to consider whether to approach Mr. Thomas or not. You selected a totally unaware, blameless victim. This was in a residential area in front of members of the public at night. Their terror and shock was palpable to the court. You didn't stay at the scene having achieved your intention. You made off and you disposed of the murder weapon. You then evaded capture for a month, involved yourself in a car chase and then gave the false details. You were also a man with previous convictions for serious violent offences with weapons, and you were driving whilst disqualified that night with a very large knife on you. I will not add any sentence in relation to count 2 other than a concurrent sentence, as it is already reflected in the term that I must set, you having brought this knife to the scene of this murder. You are now 34. You have a teenage daughter who is now without parents. I have read 5 statements sent on your behalf from your mother, your sister, your daughter, and those who support you. It is clear that your family love you and will feel the effect of the sentence that I pass acutely. You didn't think of them when you were killing Mr. Thomas, and the effect of this offence on them is your responsibility. I do bear in mind that the people who spoke for you love you and have found you to be loving and supportive, and that you can work and that you can inspire affection. There is a gap in your offending, but the commission of this crime shows your violent tendencies were still active and reignited that night. I have read a letter from you that bears the title Letter of Remorse. It is concerned mainly with you and your family's own troubles and the effect of this case on you and on them. It takes no responsibility for Mr. Thomas's death. It describes how it is only with the benefit of hindsight that you wish he was still here. It ends with the line, "There is nothing I can do to bring him back to his loved ones." It is not a letter of remorse. It does not even contain the word, apart from the title, and it does not contain any expression of regret for what you have done. It shows me, in fact, that you still accept no responsibility for the murder that you committed. Without mitigation, you would serve 30 years for this terrible crime. Stand up. There is, in fact, little mitigation for your actions, despite the considerable efforts of Ms. Parr, King's Counsel, on your behalf. You will go to prison for life. There will be a concurrent sentence on count 2 of 3 years. You will not be eligible for release from that life sentence until 29 years have passed. The days that you've spent on remand must count by law. Therefore, the minimum term is 28 years and 41 days. I repeat, you may never be released if you remain at risk. You can go.